Well, I am live now. Thank you very much, everyone, for joining me. You know who I am. I hope you do. But if not, my name is Lior Samfiru. I'm the employment lawyer. I'm one of the founding partners of Samfiru Tumarkin LLP, where we are the biggest employee side law firm in this country, operating in Ontario, in BC, and in Alberta. And what I do when I'm not here is I solve workplace problems. I'm an employment lawyer. But what I do when I'm on this session right here in front of you is I answer your questions about employment law. I tell you what you need to know about your workplace rights. I tell you what to do if you're facing a workplace problems, if you have a job, if you had a job, if you're given an ultimatum, maybe your boss is threatening you, maybe you're not sure if what your boss is doing is legal. Well, whatever the issue, whatever the question that you have or the problem, ask it. I'm live right now. This is a live Q&A session. I can talk here about employment law for a long time, but it's much better, more interesting for you and for me, frankly, is if you ask your question, if you give me an opportunity to help you so that we can all feel better about our workplace rights. I'm a very big believer that we all have a right to know what our rights are. And that's why I'm here. That's why I'm on TV. That's why I'm on radio often, telling you what you need to know. I'm trying to balance out the scale, so to speak, even out the playing field, whatever the right analogy is, to make sure that you know what to do if you're facing a workplace problem. Now, beyond just being here on this stream, you can always contact me in the office as well. If you want to have a private phone chat or a private email exchange, it's very, very easy to do that. All you have to do is you go to employmentlawyer.ca. Again, employmentlawyer.ca. You see that address below me. And when you go to employmentlawyer.ca, not only can you read and learn a lot about your employment law rights, there's a lot there, but you also get phone numbers, email addresses for me, for my team, for everyone at our office. It's all there for you. So for me to roll up my sleeves and get to work to actually help you solve that workplace issue, to enforce your rights, employmentlawyer.ca is the place to go. But that's for after. Right now, again, I'm Lior Samfiru. I'm the employment lawyer. I am here live right now answering your questions about your workplace rights. So if you're struggling with something, type it in, hit enter. I'll see it, I'll read it, I'll answer it, and you walk away with that knowledge. So don't be bashful. I know sometimes you're not sure, and because of that, I often get questions right at the end of the session, and then I may not be able to get to it. So if you're watching right now, don't wait till the end of the session. Ask your question right now. Now, as we're waiting for your questions to come in, there's a list of things that I wanted to go over, and I've called the list things that you should never do. Okay, so I'm going to list a few things that you should never do in terms of your workplace rights, in terms of employment law. And the first thing I'll mention is you should never sign an employment agreement without knowing and understanding exactly what you're signing. So here's what happens. Most of the time when you're presented with an employment agreement, job offer letter, contract of employment, whatever you want to call it, you're going to look at the things that are number based. What is the salary? What's the number on the salary? How many weeks vacation? 2, 3, 4, etc. You may look at how much is the bonus. All those number-based things. And of course, those are important. I'm not trying to tell you that they're not. But there are things in that employment agreement that you absolutely have to look for that could be a lot more important than if you get 3 or 4 weeks vacation, or whether if your salary is $50,000 or $54,000. So what are those things? For example, there could be a term in the employment agreement that limits your future severance, and it could have a massive impact. It could be the difference between at some point getting 4 weeks severance and getting 18 months severance. That could cost you tens of thousands of dollars, even hundreds of thousands of dollars, because you signed that agreement not realizing it. There could be a term in the employment agreement that allows the company to put you on a temporary layoff whenever they want. They don't have a right to do that unless you sign an employment agreement that gives them that right. There could be a term in the agreement that allows them to change your job duties, your responsibilities, your pay even. All those things are things that are not legal for your employer to do unless you sign the employment agreement that lets them do that. And too often I see employees that sign these bad agreements not realizing it because they focus just on a salary and a vacation, etc. So now you know better. If you're presented with that employment agreement, understand what you're signing. make sure you get it. And one way to do that, if you're not sure, is send me a copy. Let me read it, and I'll tell you what it means, what it does, and if it's something you should be worried about. The good news is you can negotiate those things. Okay, it's not hard. So you don't want to make any mistake by signing agreements that limit your entitlements, that take away your rights. So be very, very careful with that employment agreement. All right. Hopefully that makes sense. I'm going to continue soon with my list of things you should never do. But right now, I'm going to start taking some questions. Ask your questions. You're watching. I know you are. I'm live. I'm Lior Samfiru, the employment lawyer, here at your service answering your questions. So the first question of the day comes from Facebook from Nadine. I worked for my last employer for 3 years in a communications management role. My contract was for an indefinite term and says that I operate as an independent contractor, and therefore the employer would not deduct EI and CPP. I submitted an invoice once a month for my hours. Should I start by filing CPP-EI review with the CRA? Do I need a lawyer for this? So, and again, I'm not sure. I'm assuming what Nadine means that she was actually let go. Well, here's the thing. Yes, you can apply for CPP and EI, but there's a bigger issue here. You've probably been misclassified. You're probably an employee. It's a very common situation that you've been misclassified as a contractor, but the law considers you to be an employee. And if that's the case, then you're actually owed severance. And after 3 years, if you were let go after 3 years, you could easily be owed as much as 6 months' pay. You may be even more than that. So we need to get you that compensation. It's not just about the EI, it's also about your severance. By the way, you could also potentially be owed vacation pay or overtime pay. So there's a lot of things that you're owed here, Nadine. So you need to connect with us off air. Okay, I want to understand more about your role, etc. It is a very common situation. People have been misclassified. If you have a job, you go to work, you come back home and go back the next day to do the same thing, you are an employee. Doesn't matter how you pay your taxes, doesn't matter what the company you work for says that you are. The law makes that determination. You're probably an employee. Again, my name is Lior Samfiru. I'm the employment lawyer. You can see the QR code below me. You can scan it if you want for my contact information to reach out to me off air. But right now, I'm live right here on social media answering your questions. So ask your questions. You see how easy it is. Nadine did it. You do it as well. I'm going to continue answering questions right now. In the meantime, ask yours. Philip on YouTube has the next question. Suspended employment yesterday for failure to verify a customer's security PIN or password before telling the customer their service was cut off for billing matter. I feel that it will result in termination. So first of all, were you suspended with pay or without pay? Because generally a without pay suspension is not legal. If it results in termination, if this was an isolated incident, you made a mistake, we all do, by the way, even me, believe it or not, if you made a mistake and it's a one-time thing, it's not 5 times you've done it, if they let you go, the law would consider that to be a without cause termination. And that means, Philip, they're going to have to pay your full severance. Now, they may try to say, oh, we think you made this mistake, so we're going to let you go without severance. If they do that, that would be a wrongful dismissal. Okay, they would owe you severance. It's generally almost, it's extremely difficult, let's put it that way, to fire someone for cause because of an isolated incident. It would have to be something like theft or violence or fraud for you to be let go for one incident for cause. So if they let you go, Philip, I can't stop that, but I can definitely make sure you get your full severance. And again, depending how long you've been there, you could be owed as much as 2 years' pay. So if you are let go, Philip, if you are let go, call me as soon as possible or email me. Again, my contact information, Philip or anyone else, you can find at employmentlawyer.ca. Again, employmentlawyer.ca. All right. Next question comes to us from Randolph. The winner so far for the best name, Randolph Butterknobs. Oh, love it. On YouTube, are for-cause terminations due to company COVID policies being upheld by courts right now? There has been no court decision dealing with the issue of whether it's just cause to terminate an employee for because of vaccine policy. That we've had no cases anywhere in Canada dealing with that issue of just cause as relates to vaccines. I've said this before on air. and I'm going to repeat that in my view, and I feel very strongly about it, if an employee is let go because of their vaccine status, it's not a for-cause termination. The law is not going to consider that to be for cause. Okay, it would be a without cause termination, meaning the employee is owed severance. So that's the answer, Randolph. At some point, we may have court decisions. As we stand, there have been no court decisions anywhere in Canada on this issue of just cause. All right, next question. Oh, Philip has a follow-up. I don't know if my suspension is without pay. They never said, but just advise me to log out and go home. So here's what I would do, Philip. If it's without pay, okay, and over the next, well, today is Wednesday, right? If by Monday you're not back to work, if you're not getting paid, follow up with them. What's going on? If they don't answer, or if they don't give you a date to come back to work, let me know. That suspension, if you are suspended without pay, that alone can be considered a termination that entitles you to severance. They're not allowed actually to suspend you without pay. So let me know what happens there, and happy to connect with you. Again, to connect with me, easy to do, employmentlawyer.ca. Okay, guys, you see how easy it is to ask questions, right? No problem, easy to do. I give answers. By the way, my contact information, you see it below, including that QR code that you can scan. But right now, I'm going to continue answering questions. You can ask yours, please do. On Facebook, question comes up to us from Eric. Is it legal for employers of rotational workers or offshore oil and gas merchant mariners to fire employees for at-home consumption of cannabis? So if in fact, in a situation, let's put it that way, okay? In a situation where it's very safety sensitive. So, you're operating heavy machinery. If you make a mistake, something can happen. People can die. Yeah, an employer may well be able to let you go if, in fact, you're using cannabis, because there's a real risk that it may impact your job. Now, that's going to be very difficult to do. I want to be clear on this. But in those situations where you're dealing with offshore drilling, gas, heavy machinery, that's one of the very few times where an employer may say you using cannabis, even if it's off work, is too risky, because you may still be under the influence when you come into work. And if you're not at 100%, 97% is not good enough. If you're less than 100%, people's lives can be in danger. So that could be the type of case. But again, I would need to know the person's job. If they work in the office, it's not a problem. If they operate the machinery, very different. All right. By the way, guys, you see how easy it is to ask questions. My name, by the way, for those joining us, Lior Samfiru, the employment lawyer, one of the founding partners of Samfiru Tumarkin LLP. We operate across Canada, and I'm here at this time on this day every single week for your benefit, hopefully answering your questions. So ask your questions right now. And the next question today on Reddit comes from No Robots, another great name. What's wrong with robots? I like robots, but anyway, No Robot says, my contract states I'd be working full time at 40 hours a week. I'm only working 37 and a half. I asked about this, but our trainer said, oh, sir, we have to update that. Is this something I should be looking into? I feel kind of cheated. Well, as a practical matter, could you, if you were to leave now, could you take legal action against them for those hours that you've missed since you started? Yes, you could. Practically speaking, you're probably not going to do that. It's not even necessarily going to be a constructive dismissal, because that reduction is not significant enough. It's not more than 15% of your hours. So as a practical matter, unless you're going to leave anyway and you want to take them to small claims to take legal action for those hours you lost, which you would win, by the way, probably doesn't make sense. Again, not from a legal standpoint, just from a practical standpoint. But you have that option. I certainly wouldn't do that if you continue working for them. You're not going to take legal action against them while you're still working there. So that's what you have to do. Obviously, not a good way for the company to operate, kind of irresponsible if you ask me, but it's going to be tough to do something given the amounts involved. That's what I mean there. So you see how easy it is to ask questions. You see how easy it is to get answers to those questions. So ask yours as well. Again, I'm Lior Samfiru, the employment lawyer. You still have time for those questions. As we were waiting for the next question, I told you I was going to go through a list of things you should never do. And I've already said, don't ever sign an employment agreement without understanding exactly what you're signing. Well, the next thing on my list is, and this is really something I feel strongly about, is don't get your severance advice online. So if you want to know how much you're owed, if the company's offer is good, don't go to Google and Google severance or what's my severance. My God, there's a fountain of misinformation out there when it comes to severance, when it comes to what you're owed if you lose your job. The reason I started doing media 10 years ago is because I was so frustrated with all that misinformation online. And every single day, every day, dozens and dozens and dozens of people, maybe hundreds of people across Canada accept terrible severance offers. Why? Because they get wrong information online. They think they can get the information on Google. So you may go online and you may find out something that, well, if you're let go, you're owed a week's pay for every year of service. Or you may find you're owed 2 weeks' pay for every year of service. And think, well, okay, well, on that basis, I'll accept the offer that they've given me. Seriously wrong. No, that's not the case. You're not owed that. You're owed significantly more than that. Okay, and there's a lot of misleading information online, confusing information, incomplete information. So please be very smart about that. Once you sign that severance offer, you can't go back. There's no changing your mind. Even if you realize, oh, wait, I made a huge mistake. They owe me another $45,000, but I accepted it. Can I get out of it? You can't. Every week, I speak with people that want my help getting out of the severance offer that they've signed, and I can't help them because it's too late. So what do? If you want to find out how much severance you're owed, the real amount, the correct amount, the legally accurate amount, all you do, well, you can always call me, by the way, it's easy, but there's something else you can do. You grab your smartphone, your tablet, and instead of going to Google, you go to pocketemploymentlawyer.ca. Again, you see that address right on the screen below me, pocketemploymentlawyer.ca. One of the first things you'll see there, the first thing actually, is our Severance Calculator. Ta-da! There's your answer. Severance Calculator. It allows you and it calculates for you how much severance you are owed. It's completely free. It's completely anonymous. It's easy to use. It takes moments. Okay, and you answer 3 questions: how long you worked, your age, and the type of job. You just pick the answer from a drop-down menu, and it's going to tell you if you're owed 4 months severance, 18 months severance, 24 months, or whatever the amount is. It's going to calculate that for you. Easiest, fastest, accurate way to find out what you're owed. Make it the very first place you go to if you lost your job, if you think you're going to lose your job, if you're curious, check it out right now. By the way, you'll be surprised by what you see there. All right. All right. That's it. Now, continuing to answer your questions live here on social media. My name is Lior Samfiru, the employment lawyer. Let's go ahead and answer some questions. Suzette has a question from YouTube. I was on short-term leave for medical reasons. My employer said they no longer have a position for me to return to and said they will keep me updated. How long are they allowed to keep me off for? They're not allowed to keep you off at all. So now you have 2 options. Option number 1 is you wait. And how long? I have no idea, as long as they tell you to wait. That's option number 1. Option number 2 is you can treat this as a termination. They've now terminated your employment and they owe you severance. So they don't have a right to keep you off at all. If there's no job, they have to pay you severance. Now, there's another thing here. And I'm always very concerned when someone tells me I was sick, I was off on a medical leave, now they don't have a job all of a sudden. Because if they don't want to take you back because of your leave, or they're not trying hard enough because of your leave, that could be a human rights violation. That's illegal. So they may owe you additional damages. Now, there's actually, I said there's 2 options. Suzette, there's a 3rd option. And the 3rd option is this. If they hear from me, they may just bring you back right away because they're not going to want to kind of mess with me and with you in that situation. So if you do want, you want to go back to work, you don't want to wait, you don't want your severance, you just want to go back to work, I can probably make that happen. Okay, so you can wait, see what happens, you can get severance, or I could try to get you your job back. If you want your severance, if you want your job back, connect with me. Okay, employmentlawyer.ca to do that. You can even scan that QR code that's on the screen right now. When you go to employmentlawyer.ca, you'll get my phone number and my email address. So that's what your options are, and I can help you with your severance or your job. All right, that's a great question. Love that question. Very important one. Ask yours. You see how important or easy it is. You still have some time. Next question from N. Stinson on YouTube. Are you currently getting a lot of calls about employers attempting to force office workers back into buildings? Absolutely. In fact, over the past 6 months or so, I've been getting lots and lots of those calls. So here's how this works. Generally speaking, if you were working in the office before COVID, then your employer is allowed to tell you, now you have to come back, even though you may have worked from home for the last 2 years. And your employer is allowed to tell you, come back to work. Now, there's a couple of exceptions to that. If you were hired during COVID, so you've always worked from home and you were never told you may have to go back, then yes, you may be able to say, no, I'm not doing that if you were hired during COVID. The other exception may be a situation where your employer has told you at some point over the last 2 years that, just so you know, this working at home is going to be permanent, and now they've changed their mind. If you can prove that they've told you that it's going to be permanent, then yes, you may be able to refuse to go back. In other circumstances, yeah, your employer is allowed to say, we're going to go back to the way things were before COVID, 2.5 years ago. They can do that. All right. So hopefully that answers your questions. And Stinson, any follow-up questions, you know what to do. You can ask. You can always contact me also at employmentlawyer.ca. All right, continuing with questions. Ryan on YouTube has the next question. I've been employed for nearly 5 years. The last 8 months have been in a management position. They are demoting me, and I went on stress leave, and they've changed my hours roll upon my return. Well, what you've described right now is a constructive dismissal. If in fact your responsibilities have changed, your hours, your pay, all those have changed, that's a constructive dismissal. Absolutely. Which means now you have two options. You can accept this change and continue working. Sure, you can always do that, of course. Or you can treat this as a termination and get severance. By the way, your severance, if you choose to pursue it now, is going to be calculated based on what your salary was before they made the change, which is a good thing, obviously. So you can treat that as a termination right now if you want and get that severance. If that's what you want to do, I want you to contact me and we'll get going. Now, one of the things I want to kind of warn you about, Ryan, is this. If you say, well, you know what, I'm going to take one for the team, I'll just accept this demotion and the pay cut and I'll continue working. The problem with doing that is by doing it, you've given them the right to do it again. So right now you've accepted this change. You don't want to cause a fuss. You just accept and continue. By accepting it, now they can do it again. And next month, when they reduce your pay again or demote you again or change your hours again, you won't be able to do anything about it. You're stuck. Essentially, they can do whatever they want because you let them do it the first time. So you may not want to let them do it the first time. You may want to treat this as a termination. We call this constructive dismissal. So if that's what you want to do, Ryan, you know what to do. Reach out to me through employmentlawyer.ca. Again, I'll give it to you one more time, employmentlawyer.ca. Phone number is there, email address is there. It's all there to reach out to me. So happy to connect with you and we can get going on that. Don't do anything before you speak to me though, okay? employmentlawyer.ca. All right, next question right now comes to us from Mary Ellen on YouTube. A lot of YouTube questions today. I like it. My husband worked in a chemical plant, injured 1 month in, and suffered injury, PTSD. Does he have a case? I'm not sure what you mean. Case against what? What kind of case? If he's injured, he does qualify for workers' comp benefits, but was he let go? So again, I'm not sure exactly a case for what. If you elaborate, I'll be happy to answer that. All right. And Stinson does have a follow-up, says, thanks, you rock. I appreciate that. Is it correct that we need legal assistance to push back? We don't always have a lot of notice. How should we respond to employer initially until we reach you? There's not much that you can do. You can tell your employer you don't want to change, but there's not much you can do. We have to make a decision, right? The decision, do you accept or do you reject? So it's okay to continue working for a few days. So let's say they say effective Monday, these changes happen. And let's say you can't speak to me until next Friday, just as an example. It's okay to start working at that new role for a few days, and then we'll deal with it once you speak to me. So there's nothing you need to worry about that. What you can't do is work in that role for a month or 2 months and then decide to do something. By then it's too late. But a week, couple of weeks, even 3 weeks is not a problem. So hopefully that makes sense, and Stinson, but probably not a good idea to wait in a situation where your employer is imposing very significant changes to the terms of employment. And you can connect with me, send me an email or call today, and we'll connect as soon as possible. We may not actually be able to speak today, but I'll make sure that you and myself or my team connect as soon as possible. So that hopefully helps. Oh, we have here a follow-up from Suzette. What if we can't speak to you before we have to sign back an offer from an employer? My husband had a deadline for his severance when he was let go a few years back. So let me make it very clear, Suzette. Every severance offer has a deadline. You have to sign this by Friday, by Tuesday. Every offer has a deadline. Here's the thing. That deadline is meaningless. Okay, your legal rights, don't expire on Friday. Okay, so it's not like something magical happens on Friday and your legal rights expire. In fact, your legal rights don't expire for 2 years. That deadline is a pressure tactic. That's all it is. So ignore it. It means nothing. So if you want to be nice to your employer, say, I need more time. I'll get back to you on Wednesday instead of this Friday. But you don't even need to do that. So that deadline is meaningless. What you have to do is get advice, even if it means going way past the deadline. It's irrelevant. All right, 90% of the people, when they're let go, are owed much more than what they've been offered. So don't worry about that deadline. Every week, I've said this a few minutes ago, every week I speak with people that accepted their offer because there was that pressure, there was that deadline, they were afraid, and then they realized they made a mistake, and they call me and they say, Lior, I made a mistake. I know that, my bad. Can you please help me? And the answer always is, no, unfortunately, I can't. I wish I could, because you signed it. So that deadline is meaningless. Ignore it. It's a pressure tactic. Your rights do not expire for 2 whole years. Let me give you an example. So let's say for whatever reason, I owe you $100. Okay? I owe you $100. What if I said to you, Suzette, I will pay you $30, but only if you accept this by Friday? You would look at me like I'm crazy, right? First of all, you owe me $100. So why would I accept Tuesday or 30? And how dare you put a deadline on that silly offer? Well, that's what employers do. They offer you less severance than what you're legally owed, and they put a deadline on it. So that's why you don't have to worry about it. Hopefully that makes sense. All right, I'll take another question here. Next question comes to us from Mary Ellen on YouTube. Let's see, I think Mary Ellen. Yes, Mary Ellen's husband was injured at work. He has text messages indicating a toxic work environment and termination by a supervisor text as well. Lunch combined with break, many wrong. Okay, well then obviously he needs to contact me. If he was let go because he was injured, by the way, that's completely illegal. That could be a violation of human rights legislation. It could be a violation of workers' comp legislation. He's also owed severance, even if he only worked there for a short period of time. So yes, there's a lot to discuss. So Mary Ellen, I appreciate you contacting me here. But the next step is to have your husband reach out to me at the office. And to do that, you see that address below me. All he has to do, or you have to do, is go to employmentlawyer.ca. Again, employmentlawyer.ca. You can even scan this QR code here on the screen below me, and it will take you to my contact information. So happy to connect with him, talk to him, assess what he's owed, and advise him on what to do. So happy to talk, Mary Ellen, with you or with him. You know what to do now. Now, a reminder here as we finish our session. Tomorrow, my colleague, Alex Lucifero, will be back here at, I believe it's 12 p.m. Eastern, 9 a.m. Pacific time. So he'll be here to talk with you about employment law, about disability law, if you're off on disability leave and your rights in that situation. What happens if your insurance company is giving you problems or denying you or threatening you? So stay tuned for that tomorrow with Alex. Thank you very much for joining me today. My name is Lior Samfiru, the employment lawyer with employmentlawyer.ca. Feel free to continue the conversation on phone and by email afterwards. I'm available, happy to talk. Otherwise, I'll see you back next week. As always, I appreciate you being here. Thank you. Take care.